everyone to our live Zoom, which we've not done before. I think most of you are muted, but you will be able to unmute yourself if you do want to ask a question, so please feel free during the course. I think you all know who I am now. I'm Jane, and joining me today is Peter Barton, which I'm sure you know as well, head of Ashfords Equity Release, and he's very kindly come along for the 5th episode. We've already done leases, the process, LPAs and vulnerable clients, but today is your opportunity to ask Peter any legal questions. So we'll kick off with the first one, if we may, Peter, if you want to say hello. We've got a fair few in.
Thanks, Jane.
The first question came from an Alan Barrett. I'm not sure whether he's with us today. Can't see him on there. So I'll read the question. Why will lenders not in general not lend on a conventional mortgage or an equity release where the ownership of the property is in a trust? I know trusts can have special issues, but surely a legal solution could be found to overcome any issues of concern.
Right, thanks for that one, Jane. I would say that in the conventional mortgage market, and that straight away, that isn't my speciality, but with my historic hat on, I do know that sort of in the conventional mortgage market, there are one or two products that will lend where there was a trust involved. And the one that principally jumped out at me was certainly a NatWest mortgage. And this is, and we're going back a few years, obviously, I'm a trustee of various trusts within Ashfords for clients. And we have done trustee mortgages before, say via NatWest. In the equity release market, I think this goes back to the reason behind all this. It goes back to what is actually going on here. It is a owner-occupied residential mortgage. So what the lenders want to see principally is that the same people on the deed are the people on the mortgage deed and also actually physically living in the property. Because if they're not, and if it's trustees' mortgage deed, you'll have less control over the property of your trustees in the sense of, if the mortgage company wanted to repossess, and you've got, for example, tenants or other parties in the property, it's a lengthier process in getting them out. So actually the occupants haven't signed up to the mortgage deed. I appreciate that documents could be put in place, but principally as well, there are the tax reasons. As if you've got trustees living signing up to a mortgage, and it's other people living in the property, you may have a capital gains tax issue, which may take away from the loan. So the main reasons are tax is one reason why the equity market won't consider it, but also the principles of if they had to repossess, they would want to have an easier process into that repossession process, rather than having to instigate repossession proceedings against trustees and then potentially having to look at who's in the property, and certainly if they're older people who are beneficiaries of the trust who've been there an awful long time, there would be assured-shortable tenants. They'd have much greater rights, almost like secure tenants, if the danger. So, and when I say the word secure tenants, most people quiver, and which would devalue the property and the potential sale value of that price, because you really can't force them out. So that's principally why it's the repossession point, and it's just security for the lenders. And the whole principle behind equity release is it is owner-occupied mortgages.
Lovely, thank you very much. I will make sure Alan gets your answer. Copy this. The next question comes from John Cobbold, who I believe is with us today. So we might like to put his question to Peter, please.
Case with the lender. Lender has valued, they're happy, done their inquiries, they have no issues. But there is a leasehold. Sorry, I'll rephrase that. There's a management company sitting on top of 3 leases, and there are 3 flats in one building, a lovely historic building, and the 3 leaseholders live separate lives on 3 different floors, run their own lives, have done for nearly 40 years. Lenders have written saying, can we have a reference, please, because from the management company? And one of the questions of the 5 is, has the lease been conducted in a satisfactory manner? 2 of the now 4 management company individuals, so it's the 3 original leaseholders, plus one of the leaseholders' new partner, has refused to sign. Now, the reason for refusing to sign is they took issue many years back about the running of this health business by the lady in one of the flats, all done with everybody's consent. It went to court. The court found in favour of the lady. The council got involved. They gave 10 years to appeal. No appeal was held. And so the council said, yeah, everything's fine. You can't now appeal because that was 10 years ago. Circumstances have now changed long ago. The lady's not conducting the same level of business that she was. Lender's happy with it all, but they're refusing to sign the form. What, if any, right does the leaseholder, who's a member of the management company, have? Can she give her version of events and someone takes a view? What's the circumstance where someone refuses to sign because of a historic dispute?
You're right. I think, John, you don't need me. As ever, you've answered the question. Is in this situation, any person can refuse to sign something if they're that grumpy. But actually, I would say the borrower in this situation should put forward the history of events, probably attach the court order, or whatever, get the case summary, whatever came out from that, and put it through to the lenders, because ultimately any sale of the property could be prevented by that one person. The sale can still go through. So I think, and that's what always the lenders are worried about, is actually, if we need to repossess, can it be sold? Well, yes, it can, because there is no ongoing dispute with that other flat, really, apart from the fact they're being grumpy. So I don't think the lender would take a positive view. I'm actually surprised that the lender's solicitors have asked for a consent from every other lease holder. That does surprise me, because normally you'd have one person that is in charge of the management company, be it the secretary or be it or one director, to whom, I would always say, if there were 4 flats in a block and they're all members of that management company, obviously you can't sign off your own consent. You can't say, no, I'm happy with the way I behaved. I would ask John and say, John, you're borrowing this money. Who's a nice person in the block who will just confirm that we behaved? And it would go to the, having to ask. I've never come across a lender or their solicitors having to, or insisting that all the other leaseholders sign off an approval.
The next question that's coming from Angela Newton, which I don't think is with us. Angela, no? Quite a simple one. Please, can you confirm the fees associated with adding a person on the deeds?
So with adding people onto the deeds, this goes back to the FCA report from early in the summer, on the basis that we need to be careful that clients get proper advice, they're not rushed into things, as well as backed up by what the about making sure you're not in conflict with anybody. So from our perspective, if we get a client coming in saying we want to add our husband onto the deeds, the additional fees of the panel solicitors are £350 plus VAT. But, and this is a big but, obviously under the legal rules, we cannot act for Jane and John, and then Jane separately and putting John onto the deeds, because there's a potential for conflict. Because Jane might be saying to me, I want to give John 1% of the value of the property, even though we've been together for 40 years. And John might be saying, but no, we've been together for 40 years, I want 50%. So you instantly get into that conflict. Or Jane might be saying, I don't want to add John, because you've bankrupt more times than I've had hot meals. So I want, there's so many areas for potential conflict that we always say, Jane, we can act for you both in doing the equity release, and we can act for you in checking off the documents going to every says, but Jane, you will need to take some independent legal advice. And certainly one of my traveling solicitors has set up a company that deals with that aspect, so we can kind of pass clients over to that independent company to deal with that. And that's coming in about £150 to keep that separate independent advice. Okay.
I'll pass that on to Angela so that she's aware. The next question comes from Ian Kinneborough. I'm not sure whether he's with us, but I'll read his question anyway. Issues with 2 title deeds and the ease of creating a new title and the land registry service levels.
So 2 titles, this is an interesting one. 2 titles shouldn't be an issue at all. We've had ones with 2, 3, 4 different title deeds. Now, there's a myth that we need to merge those titles into one, and you can do that. The Land Registry, interestingly, don't actually like doing that, and you really have to justify why it's necessary. Lenders will not insist on titles, 4 title numbers or 2 title numbers becoming one. So there's no actual lender requirement. And any lenders on the line, please do feel free to jump in and tell me that I'm wrong. So there's no lender requirement. All that you do on the mortgage deed is you list under the property to be charged, you list the 2 or 3 or however many separate titles to be charged. If you want to go ahead, and try and merge them, you're looking at current timescales. If you expedite the application, about 4 weeks to do that. There won't be a charge at the Land Registry for doing that. But as I say, the Land Registry, A, they're not very quick at the moment, and B, you really have to justify the case. But actually, there is no need to do it. No lender that I've dealt with over the last 23 years since I was 14. Thanks, Jane. Satellite day relay between me and Falmouth is all I can say. Is there is no requirement by lenders actually to merge the titles. They're quite happy to have a number of separate titles on a mortgage deed.
The Land Registry service levels, I mean, are they taking that much longer?
Am I allowed to say abysmal?
You are.
Abysmal at the moment.
6 months?
I think if it was a first registration for unregistered deeds, you'd be looking at minimum 3 months, 3 to 6 months. If you're just trying to do a normal application, so we're trying to change address, change names, if we accidentally sent it in and hadn't asked it to be expedited, you'd be looking at 4 to 6 weeks. Whereas then on a normal, outside of the pandemic situation, you're looking at 2 or 3 days. But with
so it's very.
If we expedite things, you're looking at about 2 weeks.
So following on from the splitting the title, we do have instances where we have to split the title because there's too much land. And do you find that all lenders accept this? Because we have had instances where some will and some won't.
It's a tricky one, this one, Jane, and certainly, thinking of the best lenders, for example, like Pure, they're always happy with the title split. Now, you will find, obviously, there's one lender on the market. Any advisors on the call who want to know who it is, speak to Jane, she'll tell you. There's one lender on the market that won't insist on a title being split. So the situation, guys, is the value goes around and there's like 10 acres of land with it. The lender won't want to charge all of that. They want to charge, for example, 3/4 of an acre, basically the garden and the house. And one lender in the market will just say, well, you don't have to split the title. They will put, as I've said to people before, almost like the Simpsons moving dome, where they'll put a dome, they'll put a charge over the property and the garden without having to split the deeds. And actually, in my mind, that's quite a benefit, because if you think of some people that might have a paddock or a potential big garden, a very large garden that they've got earmarked for development later on, the danger is if you split the deeds, if a lender insists on splitting the deeds, and you then develop that land later on, there may be an argument by the revenue to say, well, hold on a minute, that bit of land that you split off clearly isn't part of the curtilage of the property. So as such, you have to pay capital gains tax on. Whereas if it had been kept as one big title, then there's a harder argument by the revenue to say you should pay capital gains tax on it because it's part of your principal private residence and thus exempt from that. So part of it would be good to have a charge apart rather than splitting it off. There are a few lenders that will say we want the split, and speak to Jane or myself if you want to know. Some lenders will say, actually, we want it split before completion. Now that is a royal pain in the neck, because of course, if there's a mortgage on the deeds, an existing mortgage on the deeds, and you want it split off, that means that the clients have got to go to the lender to get permission. The lender will want to send out a valuer and want to charge, and then may say, no, if that existing mortgage is a significant one or still being repaid, why would any lender want to reduce the security of their assets? So they're likely to say no, and it will probably take 6 to 12 months to get that split. So just be careful. The majority of lenders are fine with the title split, and it can all take place simultaneously on completion. Remember, people, before you ask me, the main thing that the lenders want to see, or the lender solicitors, is a decent plan. We cannot accept a hand-drawn plan on the back of a cigarette packet, and I use that example because I've actually seen that, because the land registry will look at it and just throw it in the bin. They want a properly drawn up valuer's plan that shows dimensions so they can identify the land correctly. You know, so that's always the trickiest bit in the whole process, is a properly drawn up plan. But I say there are a couple of vendors that will insist on it being done pre, you know, an application going ahead. Only a couple, but the majority will accept it. And say one lender is happy to just do a charge of part of the land without insisting on a title split.
Yeah, we do find occasionally that the lenders aren't happy because there's not a separate access to the split, or family members own, you know, land all around it,
Yes.
which can cause problems. So I always suggest to the advisors to obviously double check with the lender in question prior to,
Yes.
you know, rather than go down the whole road of doing the full advice process and find you've got a problem. The next question we had on the desk, actually. A client has had a stroke. They still have mental capacity, but obviously their signature is somewhat different. So how would you deal with that?
Well, and we get that a fair bit, you know, because people, you know, I remember when in the words of Max Bygraves, I'll tell you a story. And I know some of you are old enough to know what I'm talking about. Thanks,
Yeah.
Jim. You know, I remember when I went to buy a car many years ago now, and did my signature on the car finance, handed them my driving license. I'm very embarrassed. Car salesman came out saying, "Peter, I know you. You know, my wife works for you, but your signatures don't match your driving license to what you've signed." And my signature changed so much over the years that it didn't match ID, didn't match anything else. He said, "Go away and practice in the car for 10 minutes. Try and we'll start again." So it's, you know, the good thing for us is if the signature doesn't match, you know, we've been to the client's house, we've met with Jane, we've seen Jane's ID, so we know it's Jane, and we've watched Jane sign it. So we can actually verify that we've seen it. You know, it may be, Jane, that the person has had an illness, or they've now developed the shakes, or, you know, I've got arthritis in the hand. So you know, we get quite a few letters and emails from lender solicitors saying, "Can you explain this?" And we can. Certainly, except, you know, I would just say, "I, Peter Barton, certify that I met with Jane Hanlon. It was her signature, but due to suffering from arthritis and it being a cold day, the signatures unfortunately didn't match." So we do get that a lot, and sometimes people have had strokes, and you know, because we're meeting with the clients, it removes any difficulty in that area.
That's brilliant. It's still doing face-to-face in these difficult times.
It is the gold standard remains, and certainly we've just taken on a new person who covers Wiltshire. So yes, the travel solicitor team is up to 26 at the moment, and we're still operating in tier 3 areas as well, which is good.
That's brilliant news. So yeah, business keeps going. That's the main thing for us all.
It does.
The next question was a waiver of occupancy. We come across these quite a bit.
Yes.
Is there any lender that doesn't require one, and why is it so important to take separate legal advice?
Right. So
first one, yeah.
Yeah. So who doesn't require it? There are several lenders that don't require it. I don't want to product place on this call. I want some commission from the lenders if we do. So I think the first point to make is all lenders, any of the lenders, can insist on a waiver if they have concerns that the occupier may have a beneficial interest in the property. That's the first thing. So even though the rules of two of the lenders are that we're not bothered about them, if they're concerned that this third party is there and has been there for some time, they have a discretion to ask the one, just because they want to make sure that that the lender takes priority. So yeah, I can see you're all waiting with bated breath. Obviously, just retirement, or just rather, they don't insist on one. They may do, for example, for a partner or spouse, if they either, but all the rest they don't require a waiver on for just. And the other one, of course, is Aviva. You know, we have had a few come through from Aviva recently, but for precisely the reason I mentioned, that they had concerns that the person had a beneficial interest in the property. So Aviva and Just are the main ones that don't insist on one. Looking at the other ones, that, there's more to life. Some of their products don't require a legal witness. They have
Yeah.
an independent witness, somebody over the age of 18 and not related to the person that's signing the document. So independent. But all the rest require legal advice. Why do they require independent legal advice? It's the legal rules again. It's the ethics department of the Law Society that I've ruled on this, and I've written to them personally and had this verified, so I know this as a fact. Jane, I can't go and see Jane and get her signed up, and then one of my colleagues can't go and see Jane's daughter and get her signed up. It has to be a separate firm. And the requirement is because of the potential for conflict, because my colleague could be saying to Jane, Jane's daughter could be saying, oh, but I've been paying £500 a week for the last 30 years, and Mum's promised that I will get the property. What's this all about? And that's also we'll be saying, we're going to say, don't sign it. So there's always that potential for conflict. Now, with an equity release waiver, I do take the point that the person that asked the question has made, in the sense of, well, on a conventional mortgage, there's far more risk of a repossession because you've got those obligations to pay. You haven't got that with equity release, but again, it's all that. What you don't want is, Mum dies 20 years after taking, out pops George, the son, from the back bedroom, and saying, oh, but Mum promised I'd get it, and then trying to claim some rights against the lender. There's a huge raft of case law going back to the 1980s. Famous one with Lloyds versus Nestle. It was one of the cases, of historically, occupiers actually winning against lenders, which is quite interesting. So this is why they ask for waivers. This is why they want independent legal advice, so that people can't actually come back and make a better claim than the lender has. Cost-wise, just so you all know, I mean, you've all probably got your own horror stories of hundreds of pounds being charged. I know Things and Bath, I always use this one. Things and Bath will be charging £300 plus VAT per document. Some in London are £500. As I said, the same person that does my independent advice for transfers also has a company that does the nationwide signing off of waivers, and that's £150 all in. So that includes VAT, just so you know. So contact me direct for those details if you need it. But certainly it's a lender requirement, because if you look at case history on occupiers being successful against lenders, it's far weighted in favour of the occupier, because the onus is on the lender to show that they have probably forewarned the occupier of the risks.
Right. Okay, that's interesting. So one should take note then. I would always recommend to the advisor that they should advise the client that any occupier should take separate legal advice, and they may be asked to sign a waiver of occupancy.
Yes.
On every case to cover themselves, to be honest with you.
Yeah.
And they should get that advice. I've got a couple more questions. Came across the desk late yesterday, actually. Adding a person to a title that's not married, how does that affect stamp duty? They did have a property in question, so this would be their second home.
Right.
Because the new stamp duty laws it's waived, isn't it, until the 31st of March, but this is slightly different because she's already got a home and wants to be added to another property.
Right. I know you don't know the answer to this one, Jane, but I'm assuming obviously she's being added to the deeds of this second property. She's living in the second property.
Yes. Yeah.
It all kind of goes back, and at that point she'll probably need to make a nomination for capital gains tax purposes to the revenue.
Right.
For capital gains tax purposes, which property does she want to be her main residence, and which one does she want to be her second home? That will depend on the level of gain that she's, the level of price increase she's got in the two properties. Now, obviously, there is speak again in March, Jane, about this one, and the stamp duty rules have reverted. Now, normally speaking, if she's living in this property and there's no money changing hands, then there'll be no stamp duty to pay, because it's a transfer not for value. So if it's her partner adding her on, he's already resident. If it's a first and main residence, there'll be no stamp duty to pay. However, if there's a mortgage on the deeds, then depending on the size of the mortgage, That is, because what seemed to be, I had an example yesterday of a situation where two sons were giving up their share in the property, but the parents were having to pay off the son's share of the mortgage,
I'm with you.
which was £700,000. Its mortgage is 1.452 million. So they were taking on a liability. The parents were taking on that liability. They came to an £11,000 stamp duty bill. So if, for example, that the one person had a 1.4 million mortgage and this part was being added on, she'd be assumed to be taking on 700,000 mortgage, even though it's being repaid on completion, to be looking at an £11,000 stamp duty bill because it's over the 500,000 threshold. That's the point of view. If you're taking on a mortgage that's over £500,000, you're outside of that exemption, and you've got a big stamp duty bill to pay. But again, for all on the call, this advice only applies until March, when the situation is reviewed. I suspect, from what I'm hearing, that it'll be extended to help the economy. But you've got to wait and see.
Oh, right. Interesting. Does anybody have any questions on the floor at all?
Can I ask?
Yeah, please do.
Where the potential applicant has a property and some years ago, i.e. more than 10, they have claimed the driveway or the alleyway between what was on the original deeds, which ran to an access front alleyway. So it's like off a main road to what Northerners will call a ginnel. But that's all long gone because some's still there, some's been claimed by other people extending their gardens, so you can't get access anyway. But the applicant who has extended their boundary sideways, does that cause an issue when they want to apply for borrowing?
If it's the applicants who have extended their driveway and without obviously getting title to the property, it's one. And John, I've got a few of these on the go at the moment, and sometimes we're only talking a plot of land the size of a table.
Sure.
Which is what's ridiculous. Now we've got two options at that point. Is actually we can tell the valuer to disregard that portion and give us the value with that bit excluded, and then after completion, the clients can make a claim for adverse possession on that little tabletop size bit of land, or if it is important in relation to the value, so the whole of that, including extended land, then all lender solicitors will want that resolved prior to completion. So an adverse possession claim for a bit of land, provided they meet the criteria, will take at least 6 months, and it will normally require at least one visit by the Land Registry district valuer. So the Land Registry valuer will come out to make sure that it looks like it's their land. It's not just a bit of scrub land. It needs to be shown to be fenced off or chained off to show that it's clearly theirs and have been used, and they've got no knowledge of who else may own it. If it's, for example, a neighbour's land that's encroached onto the applicant's land, so John owns his house, Peter's pinched a bit of his garden, nothing's ever been done about it, John's just put up with it, and then John makes an application for equity release, then it needs to be resolved.
Yeah. Okay. Thank you.
Either John digging his heels and say, get off my land, shotgun in his hand, or actually agreeing with the neighbour, okay, well, let's get this formal now, and then we'll do the equity release with it excluded.
Yeah, but in this example, the perhaps 3 foot wide alleyway that's been claimed by the house in question makes the difference between being able to park a very small car and not.
Yeah.
So that would have a significant marketing value. Yeah,
and I think if that ginnel, it's a very good Cornish word, ginnel, Jane. I've not heard that since I used to live in Cornwall, to be honest. So thanks, John, for that.
We don't have them in Essex. It's the only way I could describe it.
No, Essex is too posh for a ginnel. No, but ginnel's the right word. So if they're using it as parking, and actually, if it is actually just a shared right of way, then the fact 10 years isn't really an issue. I mean, to acquire they're looking at acquiring a right to park. Now, any of the two can object and say, yeah, get the car off the land. That's a right of way, not a right to park. A right to park is very different from a right of way. Okay. So, it could still be reinstated. I think you're looking at more like 40 years as opposed to 10 for a right of way.
Right. Thank you.
It's a lot greater onus to remove, to get rid of a right of way, and it would just be a formal letter from Peter Barton, solicitors, to John saying, stop parking your Mercedes on that ginnel. It is a right of way. Here's a copy of the deeds. Our clients do not approve it.
Yeah, thank you.
Pleasure.
Okay, well, I've got one final question, unless anybody else has got anything that they want to raise. Anyone? No? What is the benefit of using specialist solicitors, and in particular, perhaps for purchase cases?
Oh goodness, and purchase cases are the ones at the moment that we're having the most difficulty with. So the benefits of specialist solicitors, I think a lot of it, Jane, is going to be honest, it's contacts. It's with specialist solicitors, we know what's going on, and we don't bulk at the requirements that are put to us, which actually normal high street solicitors say, well, why are you asking for that? I've heard of examples of solicitors writing and challenging terms and conditions of lenders' offers. It will never, they've been approved by underwriters and the cast in stone, and you can't amend them. So on that front, it's not even an acceptance of what there is. It's kind of an understanding of what there is, and kind of reassuring the clients that it's normal. And the number, I take in calls daily from clients saying, "Oh, what about this requirement, this condition that says that the lender has a power of attorney if they want to repossess?" Is that they're not paying for someone to learn on the job. We know the answers, that knowledge, that understanding, but also more than anything, as I say to people on a daily basis, it's not what you know, it's who you know. So it is if a case gets stuck, I know someone at Enact, I know someone at Eversheds, I know someone that's Optima that I can email and say, look, this one's a real Horlicks. Can you do me a favour, or can you get your team to look at it? Let's get this one sorted. Let's get it pushed through for the clients. And equally said, doesn't even have to look. I know, as specialists ourselves in GW, Richard Espy, you owe me for the plug. We also know people at lenders, so we can phone up BDMs, even though we're not meant to speak direct to the lender. We know the BDMs, the Les Picks, the Hattie Tails, that we can phone up and say, have a word, can you just help, lean on somebody to get this one through. So is that kind of not what we know, it's who we know as much as anything. So that's why you do specialists, because it's a small market, but to getting those mobile numbers of the senior people at Eversheds and Enact is not an easy job, and it's one that I don't abuse lightly unless I really need to. In relation to a purchase in particular, those people that know George Nicola, I think Jane, you will do.
Yeah.
Infamous for his hats, and lovely guy. I always remember him saying to me at a seminar, I'm doing a Max Bygraves again here, or probably a Ronnie Corbett. And can I just say, I'd like to pay tribute to Bobby Ball, who died due to COVID. I saw the news this morning from Cannon and Ball. So Bobby Ball sadly died. So that is my generation. Anyway, but I am literally digressing off. So let's get on to changing. So yes, it's this. George said to me many years ago at our London seminar. Peter said, I've got my local guy in Essex, or wherever it is. He said he had 53 inquiries from Enact on a purchase case, and I think the most we've ever had. I saw one through today with 17 inquiries from Eversheds, and actually I smiled at them. I printed it out because I'm old school and I can't do things on a laptop. Printed it and I crossed through 9 of them, and then sent them back and said, right, these are the ones that will answer. And for well that the email to us have been done by somebody who was just doing a standard email. So again, with us, it's as much as knowing what we have to answer. Again, when we see these inquiries, we're not going to say, oh my goodness, we can't give that undertaking, because we know we have to, and we will get it across the line, and it's all legitimate. It's knowing that if we need to get to exchange quickly, I could contact somebody at Eversheds and get the case prioritised. And also it's knowing, just to reassure the clients, if you're not using a specialist, they'll be panicking. The solicitors will be panicking the clients as much as anybody else. I always say, I've had a lot of run-ins with estate agents recently, and obviously estate agents are my favourite all-time people, because they're never interested in their commission. They never, telling fibs to both sides to get things rushed through, obviously. But I've had to tell several estate agents from some big companies off recently for stirring the pot where there's no need. And I always say to the clients, ignore everybody else in the process apart from us. We will tell you the correct position. We will keep you informed. And we know that when we send off a patch to Eversheds or an act, that it will be a fortnight until we hear back from them with inquiries. And saying that, we sent one off on Monday, and I had the questions back today. So actually, Eversheds are my faves at the moment. They're doing very well. I'm touching wood. So for that reason, it's very much a, with a purchase case, it's maintaining the client expectations. It's such a stressful thing, a purchase, and we're all in our own homes. We've probably been in our homes for a long time. We forget. Jane, you've got this to look forward to.
Yes, thank you.
But it is a stressful time. You do tend to, when you got an estate agent phoning up and your days from exchange saying, oh, well, the seller's not happy of putting it on the market, you're going to have a meltdown. And my job is very much I'll have a word with the estate agent. He won't get his commission this month, and to rein it back in again, and say, well, you can pull it if you want to, but you'll be back 8 weeks again, so it'll be after Christmas before you get commission. So it's that kind of almost that bullishness of saying, no, listen to us, we will get this through.
Good job. I mean, our research has shown actually by using the specialist, it reduces the completion time by in excess of 11 days over the standard 38 days at the moment, which I think is pretty good, to be honest with you, with the current climate, that the completions are still going through.
Yeah, and we're saying, Jane, on a standard case, and I said this to an advisor this morning, if I am sending a pack off on a Monday to lender solicitors, and my team get me to do it because the lender solicitors don't like me, so they do it quicker. It's taking 3 weeks to get to completion, even on a vanilla straightforward case. I'm saying that to clients, and I'd rather say 3 weeks and get it completed in 10 days, and the clients think we're amazing, rather than saying it'll be 10 days and it takes 3 weeks. So we're now saying there's a right 3 weeks, and it's coming in about that, just on a standard case. But on a purchase case, I would say Eversheds are getting a lot better. I'll give them credit; they're getting better.
That's good to know then. It's all improving. As you know, Peter is on our panel. So we have a special deal with cases with Peter for standard ones at £650 all in, with including a home visit and VAT and standard disbursements. So just so that you know, easy to instruct either from the website or just let me know. Peter's along with GW, Richard Epsley, so the two on the panel.
Jane, right. Jane, can I just say as well, and you all give a collective groan when I say this, please do email me before you're speaking to clients, and I'll do a copy of the client's deeds. I can't, and I've said this before, and I've said this every time, and Jane will nod off now, because I've said it to her. The deeds show so much that will help maintain your client expectations, or might save you wasting your time, because it will show you the length of the lease, it will show you whether there's local authority property, it will show you whether there's joint tenants or tenants in common, whether the client's been truthful that they've only got one mortgage and not one mortgage plus 13 CCJs. It will show you whether there's an overage agreement on the deeds, it will show you who's on the deeds, whether it's actually the clients. So all of those things, it's important information that you might think, well, that's a solicitor thing, that's not our problem. It will become your problem 6 weeks down the line. We then hit a snag. So, I'm always happy to send a copy of the deeds. There's no charge for that. I'll always personally check them, so that when I send them on to you, I'll say to you, oh, just watch out for this, or do you know the tenants in common, or do you know this and this? So it's, don't be frightened to email for a copy of the deeds, or give me a ring. People seem to be frightened to phone me because I'm the boss, but anybody who really knows me knows that I'm not the boss, and I'm always happy to chat. And it's just the little things that we can do around the case that will make the case much easier.
That sounds absolutely wonderful to me, if you can get all that information, because so many times cases fall over after offer when the title's checked. So a good tip there. So thank you for that, Peter. So I'd just like to thank you all for joining us. And like to remind everyone, for every KFI you do from the AdviceWise platform, we plant a tree, which is very environmental, and we will also put you forward for a prize draw. So I thank Peter very, very much for his time, and
That's a
very,
pleasure,
very
Jane.
informative. We've already had somebody actually on the chat line to thank you. Very informative, especially when people are working on their own. So that was from Darren. So thank you for that. So thank you very much, and hopefully we'll
Thanks,
see
everyone.
you again.